I now look to Robert French to continue the case for the proposition.
Madam President, thank you, and thank you for the invitation to join in this historic debate. I took the opportunity before coming here to consult the Society's rules, a massive document I might say, to see whether there was any indication of an existing policy in relation to no platforming. I found some rules about vomiting and also a rule about booing or hissing at speakers, which was said to be a grave and pointless discourtesy, and that encouraged me. I also found in the appendices and schedules to the rules a list of people from whom you won't accept cheques. And then my eyes lit upon a heading which said schedule of unacceptable room hirers. I thought, aha, this may be a clue to an existing policy of no platforming. They turned out to be the Oxford University Ski and Snowboard Club and the Oxford Conservative Association, and in italics, for the purposes of hustings and in-camera proceedings. Now, what that means and what the history of it is, I have no idea. Now, let me turn to the topic. No platforming, what does it mean? The Joint Human Rights Committee of the House of Commons and House of Lords set out in its report last year a list of things which constitute no platforming: a decision to ban an external speaker from speaking at a university, a decision to withdraw an invitation from somebody who has been invited and who has accepted, the imposition of conditions on a person speaking that they find unacceptable, the decision by other speakers not to share the platform with an invited speaker, and disinviting a speaker due to pressure from students who oppose the speaker's views. So there's a miscellany of actions, all related of course, which come under that general heading of no platforming. But those meanings do not tell us when and against whom and for what reasons no platforming should be applied. It cannot be applied simply against anybody with whom we disagree. Otherwise, we would no platform people who admire King Joffrey, people who think Ned Stark got his just desserts, and people who think against all of the evidence to the contrary that winter is still coming. The proposition is then not simply this House supports no platforming. That in itself is meaningless drivel, and I say that as one who supports the proposition. The real proposition is this House supports no platforming when. And we give content to the when, which gives meaning to the proposition. Yes?
But the reality is people like Peter Singer, Jeff McMahon, and also Peter Tetchell have been no platformed by student movements that do not necessarily adhere to the sensible regulations and guidelines you might be about to talk about, because the student left and those who are radical often have incentives to over-amplify the so-called dangers of speakers, and that leads to the excessive no platform of people who do deserve to speak up at this very chamber tonight. Thank you.
I take that as a point of information shared with all of us. Now, the opposition, of course, cannot be content to argue that this House can never support no platforming. That also is meaningless drivel. They are driven to say this House never supports no platforming unless, because otherwise we would have an obligation to host unlawful speech. And in the penumbra around unlawful speech, speech which is intended to do no more than gratuitously insult, humiliate, intimidate, and has no other object which is worthy of an institution such as this, or of any university. So the question then, the difference between us, is to be found in our when. This House supports no platforming in when, and there unless. This House never supports no platforming unless. Nobody can simply make an absolute statement, this House supports no platforming, or this House never supports no platforming, because it simply lacks content. Now, no platforming in freedom of speech. As a general proposition, freedom of expression does not involve a right to be invited anywhere. It doesn't involve a right not to be disinvited. It doesn't involve a right to determine the conditions which relate to your invitation. And it doesn't involve a right to insist that somebody else has been invited to participate with you must turn up on the night. It does involve the right not to be prevented from speaking by others who object to the content of your speech if you have been invited and are speaking. Now, no platforming, and there's a sophisticated argument here, may be said to enhance the free speech of those within the university who feel constrained when speech which mocks them or diminishes their dignity as human beings is given a platform under the authority of the institution. And that, I think, is a legitimate basis. It's a basis which requires judgment, of course. But too broad a no platforming policy, and this goes to my when, can deprive students of exposure to and the opportunity to challenge different worldviews and to enhance their understanding thereby of their fellow human beings with whom they have to interact in broader society. As a matter of principle, therefore, no platforming does not engage a great deal with the issue of freedom of expression. Nevertheless, it must be employed with care to prevent exclusion of diverse and uncomfortable views and determination by one group of students or university officials of what they think others should be allowed to hear. On the other side of the ledger, no university can be obliged to welcome, in the name of intellectual pluralism, intellectual rubbish. There is plenty of it about. There was a wonderful essay which Bertrand Russell wrote in the 1950s called An Outline of Intellectual Rubbish. And of course what it demonstrates is that one person's intellectual rubbish is another's profound wisdom, and that what is intellectual rubbish today may become profound wisdom tomorrow. Interestingly, I went back to that essay recently and found that two examples he gave of intellectual rubbish were the proposition that gold has value and that Aristotle was wise. I noticed that this institution, this union, has itself made a judgment about intellectual rubbish. You may say it's right or wrong, when in April last year it rejected a proposal for a debate by an instructor at Oxford's Oriental Institute in which he would argue that invisible aliens are interbreeding with human beings and are deeply concerned about climate change. Now, some of you may think that is an argument which we ought to hear. Others may feel that perhaps it's not worthy of the institution. So there is a judgment to be made. Now, over all of these, in the UK, there are laws. I've been talking about norms and values, but you actually operate within a framework of complicated laws which are in tension with each other, as are the values. So you've got the Education Act 43, Section 43, which says basically there's got to be a protection of the freedom of speech of invited speakers, and that there has to be a charter or a code to deal with that. Then you've got the Human Rights Act and Article 10 of the European Convention, freedom of speech, which public authorities have to apply under Section 6 of the Human Rights Act. And then on the other side of the ledger, you've got the Equality Act and the Public Sector Equality Duty, which includes the duty to foster good relations between persons who share various protected attributes. So there's a complication of norms and legal principles which are in contention when we talk about no platforming. But there can never be no platforming. There has to be judgment. And having regard to all of the above, this House can, should, and I would respectfully submit, must support the proposition that it supports no platforming, with the silent reservation when. And it is in the when that we find the requirement for careful judgment, balancing competitive goals in a university context and legal and moral norms which are in tension with each other. That's hard decision making, but it's what we're all about. Thank you.